Hey everybody, I'm attorney Jason McGrath. How are you today? I've been a litigator for almost 20 years now, and we're going to talk about a litigation issue, specifically requests for admission. Requests for admission are one of the most dangerous things in a lawsuit and probably one of the most underutilized tools. Basically, a request for admission is asking another party to admit or deny something. And really what you're asking them to do is to admit it. So for example, if I were to say, please admit that you signed the contract entitled, XYZ, and presumably in that lawsuit, perhaps the issue of whether the other party actually signed it or not. Maybe they're saying they didn't sign it. Well, you want to phrase it in a way such that they admit it or deny it. But the key thing is to realize that if they don't respond, then they are deemed to have admit it. So you want to think about every request for admission. If it's not responded to, it's going to be deemed admitted, and so you want to phrase it accordingly. Now, these admissions or these denials potentially, but really especially the admissions, can be used in the lawsuit typically in almost any way that you could use other information. And in fact, if something's admitted or if it's not responded to, and so the court deems it basically to have been admitted by not responding to it, that pretty much conclusively establishes that point, barring some other action by the court. So again, going back to that example, if you say, please admit that you signed this contract, then you name the contract, on such and such date. If they admit it, if the other side admits it, then they really at that point don't have any good basis to go back and say, well, no, wait, we didn't sign that. You can at that point rely on the fact that they've admitted it. Now, if you're on the other side and you're receiving a request for admissions, you need to be very, very careful with how you respond. Because typically, those requests for admissions, if they're done well, try to box you in to basically admit all of the things that the other side needs to prove to win their lawsuit. So requests for admissions, underutilized, very, very dangerous, governed by the rules of procedure, civil procedure, and also cases that have talked about it. So if you're going to, initiate a lawsuit or if you're in one, then you should absolutely be propounding requests for admissions. And if you're on the other side, you need to be very, very careful with how you respond. And by the way, there's typically a 30-day deadline to respond. So I hope that is helpful to you. If you have any questions, just let us know, and maybe we can help you with your lawsuit. Thanks.